given that you've allowed grounds 1 and 2,
Yes.
2 I can see is dealt with properly under the whole success question, which is the central question for the court today. But 1, in effect, is the point of my learned friend. How would your lordships like this to be dealt with?
Well, we can certainly take, what we can certainly do, if this is what you're suggesting, is take ground 1 first on its own, hear both sides on it, and then go on to the other grounds. Is that a convenient course?
Absolutely.
Mr. Rainey, you content with that?
I am, my lord, although I suspect the argument will start trespassing into the issue of just what is success and what is relief from forfeiture. So, but
This is on ground 1.
Sorry, you mean?
I think what's being suggested is that on ground 1, which is a jurisdiction type.
Yes, which is my ground 1.
Which is your ground 1. Your ground 1. I don't see why that has to trespass into anything else.
I'm in your hands, my lord. I'm perfectly content with whatever procedure your lordship will find most
helpful.
Well, I
mean, it seems to me it can be either it can be dealt with all by the appellants, but he's quite right in saying it's your point. It's a jurisdiction point, and I think it's perfectly reasonable myself for him to say, well, you make it.
Lord, this you have my replacement skeleton argument. Yeah. The starting point I would submit is probably, having set out the history of it, which I know your lordships have read. I think in paragraph 9 I suggest that at a very early stage one ought to look at section 138 and how it works. And so I would respectfully invite your lordships to do that. Section 138 is set out in the authorities bundle, and your lordships will find that.
Tab 20.
Tab 20. Section 138 of the County Courts Act determines how the County Court deals with relief for forfeiture for non-payment of rent where the forfeiture is by proceedings. As a matter of history, this is derived from section 191 of the County Courts Act of 1959, which seen in a cross-reference. I think there was probably a similar provision in the County Courts Act of 1934. My Lord Justice Lewison traced some of the history in the Gibbs case, and there's also a little bit of the history at the end of Aeschylus. But this is a set of provisions.
It goes back to the 1850s or the 1860s.
It's part of it, at least, is almost in the same words as the Common Law Procedure Act of 1852, section 212, and very, very broadly, my submission about the history is it starts in the courts of equity. That's where relief from forfeiture starts. The common law courts simply forfeit, equity relieved. I'm sure I have to tell such experienced judges that in those days you had to file a bill in equity in order to undo the decision of the common law courts. And then as procedure and the common law and equity began more to fuse over the 19th century, what happened was that the equitable jurisdiction began to be conferred on the common law courts, which was the Common Law Procedure Acts, and Parliament gradually put more and more and more of the equitable jurisdiction into statute. And the end point of that is the County Courts Act of 1984, so that in the respect of the county court and non-payment of rent, its jurisdiction is in this section. The section is long and complicated, and deliberately, in my submission, gives the lessee, who is in default of non-payment of rent, umpteen chances to obtain relief of one sort or another. And the reason for that is because the courts of equity always treated the right to forfeit for non-payment of rent simply as a form of security for payment, and lent against forfeiture so far as they could. And Parliament has adopted that approach, which is one answer to what my learned friend says about, well, surely you can't get umpteen chances. The simple answer is yes, you do, quite deliberately, so that you don't lose long leases for small amounts of rent. So section 1381 says that it's where the lessor is proceeding by action. Section 1382 is the first relief opportunity, which is entirely automatic. And it simply says that if the lessee pays into court or to the lessor not less than 5 clear days before the return day all the rent in arrear and the costs of the action shall cease, and the lessee shall hold the land according to the lease without any new lease. So you never get an order at all if the lessee pays everything into court not less than 5 clear days before the return day. And it does have to pay all the rent in arrear, not just the rent which was due at the date that the action was issued, but you're supposed to be able to work it out from the particulars of claim. It's supposed to provide you with a daily rate and so on for mean profits. The forms also provide for the fixed costs, and this is a point I've made later, but there is a difference between 1382 and later sections, because in order to, the costs of the action for 1382 simply means the fixed costs, which are the issue fee and the solicitor's costs, which you put on the claim form, or the summons as it was when this section was brought into force. You don't get all of your costs, and that, I suggest, is one reason why you have to pay not less than 5 clear days. That's to stop, so that the landlord doesn't have to run up the costs of getting someone to go to appear in the undefended possession list in order to obtain the order. Return day, or return date, is a defined term. It means, it's all related to the old county court rules, but effectively under the old county court rules you had fixed date actions and default actions. Possession of land was a fixed date action, and a fixed date action always specified a return day, whereas a default action for payment of money, for instance, didn't. And in Sawteeth and Bolt, which is one of the authorities which I'll probably have to come, or my learned friend will have to come, it was made clear that return date means the actual date on the face of the summons, or now the claim form. The reason for that, I suggest, is that Sawteeth and Bolt explains it. It's so that if it gets adjourned off for whatever reason, and maybe there's a trial, or there are directions and lots of costs are incurred, the lessee can't change his mind and simply say, oh, well, I've got a 4-day trial listed, but I don't fancy it anymore. I'm going to pay the fixed costs and the rent in arrear, and I'm clear. Section 1382 is spent as soon as the 5 clear days before the return date is...
So this is all very interesting, but why are we concerned with 1382? Surely your point's under 1383.
I address it because my learned friend makes... in his supplemental skeleton in particular, he says that there's a distinct difference relating to the word trial, because he tries to say that there isn't a trial if you end up in the undefended possession list under 1383, and I was just setting up part of my reasoning as to why that isn't right. But I'll move to 1383. 1383 simply says that if the action doesn't cease under subsection 2, and the court at trial is satisfied that the lessor is entitled to enforce the right of re-entry or forfeiture, then the court shall order possession of the land be given to the lessor at the expiration of such period not being less than 4 weeks from the date of the order. So there's no jurisdiction to order possession immediately. But there is jurisdiction to make a longer period, because it's such period as the court thinks fit, but not being less than 4 weeks, unless within that period the lessee pays into court or to the lessor all the rent in arrear and the costs of the action. And as I say, that will be an order which is made after some sort of hearing, so the lessor can ask the judge at the return date, or the trial, however you want to call it, to make an order that relief is conditional upon all arrears. And I gave the example in my
about costs, Mr. Rainey, in that circumstance.
In that,
they won't be fixed anymore.
Won't be fixed. you would produce a cost schedule, you'd ask for all of your costs, including the
He's
costs.
got to, the lessee's got to know what the sum to pay into court.
Yes, so the order will, under 1383, specify the costs, but you would expect the judge at the return date to have assessed them and will make an order. But you're not limited to the fixed costs on the face of the summons. So if you've sent junior counsel along at £150, then probably the deputy or the district judge will say, yes, you can have the costs of that. You can have the costs of preparing any further evidence, and you'll get all your rent. So I gave the example, if, for instance, an insurance rent payable on demand has fallen due between the summons and the return date, you could go to the district judge and say, I've got some extra rent here, it's not paid, make that a condition of relief.
There are two restrictions in section 1383, aren't there? One is you can't make an immediate order of possession or a possession order in less than 4 weeks. And the other is that you can't make an unconditional possession order of any length.
That is right, my lord. And those two are statutory restrictions on the court's jurisdiction, I submit. And therefore, any order which doesn't comply with those two fundamentals is, I've used the word a nullity, but another way of putting it is it is without jurisdiction and irregular. And I'll come back to Spurgeon's in a moment. I'll try and go through this as quickly as possible, but I hope it will be assisting, because my learned friend won't have to do all this again. To continue, the way section 138 then works is that assuming, and this all assumes that the order is made under 1383, then subsection 4 gives the court a jurisdiction to extend the period at any time before possession of land is recovered in pursuance of the order under the subsection. So even if you've had an order under 1383 and been given time to pay, you can go back to the court and ask for more time. And then section 138(7) in effect backs up the point about 138(3) being the only correct form, because 138(7) then says that if, and one might say only if, the lessee doesn't, within the original period or the extended period, pay all of the rent and the costs, then the order is enforceable. I would say, but only then. And then the second restriction is, and so long as the order remains unreversed, the lessee shall be barred from all relief. So even that section contemplates that the order might yet be reversed. And 138(8) makes it very clear, just in case it wasn't clear, that an extension under subsection 4 shall not be treated as relief from which the lessee is barred by subsection 7. What that means is that you could have run out of time under 1383, not got an extension, but so long as you make your application for more time before the possession order is enforced, then you're not barred by 1387, so you get yet another chance. The section 1389 goes further and makes it clear that you might get an extension of time under subsection 4 when the period for payment has expired and a warrant has been issued. But as long as you get in before the warrant's executed, you're fine. You can apply for an extension of time. And if that happens, the court cancels the warrant. Now, all of those chances were still considered not to be necessarily sufficient, because it was possible, if the lessee didn't know about the possession order, that they could effectively run out of rope. And section 1387 does say that if the order is enforced, in effect, then you are barred from all relief. There was a case, De Palma and Victoria Square in 1985, where this came to a head. And so Parliament then added 9A, 9B and 9C, which was to give yet a further period for relief. So 9A in particular says that where the lessor has recovered possession by any means, then the lessee may at any time within 6 months from the date on which the lessor recovers possession apply for relief, and on any such application the court may grant relief. So Parliament added an extra 6 months from the date of taking possession for the lessee to make an application to get relief.
So when your client applied to set aside the order, she could have applied in the alternative for relief. Because that was in January, and 6 months had gone out till February.
Yes, and indeed I had thoughts about this. It might be argued that if you apply for relief in some form, which she effectively did to set aside the order, then that would be good enough to apply under 1389A in the alternative. So if that point ever became a live one, then I would take that point, that having applied for relief, that is good enough, and one ought not to.
So I think you're saying if you apply for an order, if you apply for the order for possession to be set aside, you can bring under it, in theory, whatever ground you want for that purpose.
Yes,
Is that
and
what you're making?
yes, and it goes slightly beyond that, because the witness statement in support of the set-aside application addressed what was supposed to happen, and it said, get relief under 138. And clearly it was referring, I think, well, query what it was referring to under 138, but it certainly did say that relief was the consequence of the setting aside which was being sought. And so in my submission that would, if it had to, suffice for the application under 1389A. Now,
That point doesn't arise before us.
it doesn't arise before you, my lord, no. One of the points which will arise and which emerges out of this is this works as a coherent set of provisions on the assumption that, which I say is correct, that the return day may also be the trial. It doesn't work if somehow the return day in the undefended possession list is not a trial. Because if it's not, and you don't then have to make an order in the form of 1383, then you wouldn't be able to apply to extend under 1384. But equally, the bar on applying for relief under 1387 wouldn't apply because you haven't got an order in the right form. So the time limits don't operate coherently. And the short answer is that the reason why 1382 refers to return date specifically is simply to make sure that you lose that automatic right for payment of fixed costs once you get to the return date. It isn't supposed to be saying that the return date can't be a trial. The trial is just whenever the possession claim is finally determined. Might be the return day if it's in the undefended list, might be later on summary judgment, might be a full-blown trial.
Now, I think what you're saying is that the order referred to in 1387 necessarily refers back to the order referred to in 1383.
I do say that, my lord, yes, and I also say that when 1383 uses the word trial, what it means is the final hearing of the possession claim.
Yes, I mean,
Which
I think, yeah. Yes, because otherwise the rest of it doesn't work.
yes,
Well, otherwise it means, I think you're saying, that all these provisions as to extension of the time for possession in the order, that's 1384, the provisions of 1387, which is the barring, they wouldn't apply.
yes.
There would be a common, perhaps the most common form of obtaining a possession order, which simply isn't met by this framework. That's what you're saying.
Well, that was the second point I was going to come on to. The undefended possession list and orders being made in the undefended list is, as you say, a very common way in which possession orders are made, and it would be extraordinary if an order at the undefended list was not covered by all of the protections which Parliament had enacted for the protection of lessees in section 138, and which is supposed to replicate the original equitable jurisdiction. So in effect, what you would have done, or what Parliament would have accidentally done by putting in a statutory codification, is actually to exclude the original equitable relief from the most common circumstance.
My recollection of county courts of the 70s and 80s was that when you did turn up to the undefended possession list, you had to call some evidence.
You did. And quite often, well, I mean, that's, you know, one used to sit there as a very junior tenant and learn one's trade by watching everybody else and seeing them come unstuck when the district judge goes, well, where's your evidence?
Registrar he was then.
Yes, originally the registrar, yes. Or sometimes the circuit judge, because circuit judges did the possession lists as well. And, you know, have you proved your title? You know, where's the evidence of the landlord's title? That's not good enough. Have you got someone who can give evidence of the rent arrears? This statutory notice is in the wrong form. Lots of undefended claims actually fail because an experienced district judge or registrar knew that there was a defect, or they were adjourned out. So it is, in effect, a trial, even if it's undefended and there is no one there to resist it.
So in 1984, when Parliament passes the Section 138, which replicates Section whatever it was of the 1959 Act.
191.
191, that's right. The procedural background was such that there would have been a determination on evidence if the payment was not made in. Remember, the payment was not made before the date specified on the summons.
Yes.
5 days before.
Indeed, and even under CPR 55, what's changed is that they're usually held in private because of human rights concerns and privacy, where it is a residential flat, so you don't have the list with everybody sitting there to learn. But they're still determined on evidence, and indeed there is evidence because Mr. Harrington of Wannocks put in a witness statement to support the claim for possession, so that is to give the necessary
You can do
evidence.
it with a statement of truth, though, can't you? You don't have to have evidence.
Yes, under the current rules, the statement of truth on a particular claim can, if that
Yeah.
contains all that is necessary, constitute the evidence.
Yeah.
But if there was a gap, if there was something not filled in, the district judge ought to say, I'm sorry, this particular doesn't provide all. The jurisdiction point arose under Section 115, 191, which is Spurgeon's Homes and Gentles in 1971. And your Lordship will find that at tab 12. And the facts can be taken fairly shortly from the head note, which is that the freeholders of a house claimed possession, arrears of rent and mean profits, alleging that the lessee was 2 years in arrear of ground rent. In the absence of the defendant, the registrar of the county court ordered the defendant to give up possession on October 15, 1970, and made an order in the form of Form 134 of the county court forms, and not of Form 136 as required by Section 1911 of the County Courts Act. And helpfully, the head note says, Form 134 was an order to give possession on a specified date and to pay specified sums, whereas Form 136 ordered the payment of the arrears by a specified date and ordered that unless the payment was made by that date, the defendant shall thereupon give possession. So pausing there, 136 is the equivalent of N27, which reflects the mandatory terms of Section 191 and later Section 1383. And then the history is that the defendant lessee didn't pay. They paid late. The warrant was in fact executed, and the application was for the warrant to be set aside and for relief, which the county court judge refused, but the Court of Appeal allowed. So the Court of Appeal allowed the application to set aside even though the warrant had been executed. And the ratio of the case was that the order was made in a form which the court had no power to make. If you take it up at page 1516 at letter G, as far as one can see from the fact that proceedings were issued on July the 30th, 1970, and the matter came before the registrar on September the 18th or 21st of 1970, it's quite clear, I submit, that this is the return date. And that in itself is largely fatal to one of the member's friend's points about the 138 not applying at the return date. Says that the registrar made the order in the form of 134. Turning over the page to 1517, at C to E, it records, sorry, between B and C it records the execution of the warrant, and says the defendant's got back in, but subject to setting aside as a trespasser. C to D, it then says that the defendant made an application for the warrant to be set aside and for relief. County Court judge dismissed it. He treated the form of order as having been a slip, and so he gave leave to amend it, so to put it into the right form, retrospectively. And he said he thought it would be unfair to set it aside. He didn't think the defendant had been misled, and if it had been in the proper form, it wouldn't have made any difference. The Court of Appeal then sets out the wording of section 191, and then at page 1518, in the sideline bar, disposes of the appeal. The court gives you the precise wording of the two forms, and then at letters at G, paragraph beginning so that, line 4, it says the two orders have quite distinct kinds of operation, different forms of order. Form 136 is designed to comply with mandatory requirements of 191 and is the proper kind of order and the only proper kind of order to be made in a case falling within that subsection, which this case does. In those circumstances, the order having been made in a form which was inappropriate to the terms of the section, then it was, in my judgment, an order the court had no power to make. While it was in the order stood in that form, it was an order which I think the defendant, if he'd known of his legal rights, of which I've no doubt he was ignorant, would have been perfectly entitled to disregard as being an order of the kind the court had no power to grant. I'm quite sure that the court would have made, or should have made, that second order run from the date the position was corrected. Now pausing there, in the light of subsequent authorities such as Isaacs and Robertson, I can't, I think, suggest to you that you can simply ignore the court order, but I can say that it was completely irregular and made without jurisdiction, and say that therefore there is an entitlement to set it aside and have it, in effect, at worst, remade in the right form with time to run from the date it is remade.
Isaacs and Robertson, I think, was a High Court order.
It was.
Which is a court of unlimited jurisdiction. I mean, one could perhaps argue that a court of limited jurisdiction, which makes an order in excess of its jurisdiction, might be different, but anyway.
I will, if I may, push that point. I was concerned about pushing it because your lordship, of course, rightly drew our attention to Gibbs and Lakeside, and there's a long passage in Gibbs and Lakeside where you, my lord, actually set out a string of cases which were made, where orders were made without jurisdiction, including the one against the Home Secretary, where you can't make an injunction against a Minister of the Crown, and yet the Minister of the Crown was in contempt. So I was cautious about pushing that point. But yes, the County Court doesn't have any inherent jurisdiction, and so it did make an order which it had no jurisdiction to make. And I could say there is Court of Appeal authority which says you can ignore it.
Yeah.
Whether that adds anything to the point that, as of right, it can go, I don't know. But I will press the point and say that on that basis, on the basis of Spurgeon, Holmes and Gentles, it is a true nullity, it is nothing.
It's not a nullity. It can't be a nullity. If it was a nullity, then you could ignore it.
Well, to be
The
fair, that
authority is clear. While it didn't discharge it, it's an order of the court.
I suppose if you're allowed to say it, in those days you'd say that it was being entitled to have it set aside ex debito justitia.
yes.
Well, then I can see that's a different point.
It is, exactly.
Lord Justice Buckley did say you could ignore it, and the other members of the Court of Appeal agreed with him. In fact, Lord Justice Sachs is even more trenchant because he doesn't like the shoddy paper on which the county court order was written. And that you see that at the bottom, page 1519H. But the point is that he does agree, as indeed does the third member of the Court, Lord Justice.
It may be a loose description of the word nullity.
Well, nullity is actually my word. It doesn't appear in the judgment. What Lord Justice Buckley said is that it's a form of order which the defendant quotes would have been perfectly entitled to disregard as being an order of the kind the court had no power to grant. And it is the county court as opposed to the High Court, so it isn't a court of unlimited jurisdiction. I will, whether it's right or wrong,
That's your solution.
so I will, if I may, I will adopt the half invitation from my Lord Justice Lewison to go further, and I will argue that it is genuinely, on the basis of Spurgeon's, Holmes and Gentles, an order which has no effect at all because it's in the county court. And arguably there's a second difference, which is that what this kind of order does, of course, is to I suppose, to complete the circle of forfeiture, because the order itself doesn't forfeit. It is basically confirming the forfeiture which took place with the service of the claim. And so there is an argument that if this order is completely worthless, then of course you have never completed the circle of forfeiture beginning with the service.
You're going ahead because I was examining the language here. So Lord Justice Buckley says that it is possible the court would have discharged that order. If it's a nullity, you don't need to discharge it.
What he's saying there is that if the plaintiff, the claimant, had realised that the order was in the wrong form, what the claimant might have done is gone and said, can we have another order in the right form, please? But he then, because it's key, because he says what the court wouldn't have done or shouldn't have done is simply to amend it by the slip rule so that the 4-week period started when the original worthless order was made. He says you might be able to get a new order, but you'd have to start your 4 weeks over again if the claimant had made such an application, which of course they hadn't. And what the upshot of the judgment of the court is that the warrant ought never to have been issued on the basis of an order in that form. The execution should never have occurred, and the defendant should be restored to possession. And for my purposes, the basis of that is simply that the order is wrong. And that is why I said in my skeleton argument, it's a shortcut in a sense. If the order is wrong, then you're entitled either to say it's just completely wrong, there should be a new order, or at worst to say it's entirely irregular and one is entitled to have it set aside. If it is set aside, it would be to, at worst, to remake it in the form it should have been with the 4 weeks. There's relief from forfeiture, that's success, and that is the short answer to the appeal. Because, putting it bluntly, if the purpose of a possession order is to gain possession, then if you don't get possession, that's success. And Spurgeon's, Holmes and Gentles is a case which was decided in 1971, but it's not the only case. There is also the case of Croydon Unique against Wright, which is at tab 5.
Is there, and I'm surprised, is there any other authority which is comparable to this of the county court making an order and it being said that it's a nullity in the sense that you want us to understand it, which is you can simply disregard it, it's just paper, nothing more. Is there no other case?
Well, I would confess that wasn't a line of research I had gone into. I simply don't know the answer to that. what we did do was see if there was any other order, any other case dealing with section 138, which was on the same lines as Spurgeon.
But you're making a much wider point.
I understand that, my lord. So I didn't go for the wider search, if you like. What we did do was see, well, has Spurgeon's been followed at all? To which the answer is, in effect, yes, in Croydon, Unique and Wright. The difference between Croydon, Unique and Wright is that the applicant to set aside was a creditor. But exactly this, it's a tab 5, but exactly the same point was taken. And one can see this point beginning on page 322 in the judgment of Sir Christopher Staunton.
300.
It's tab 5, page 322.
Thank you.
And at B he says that there came a time, as lawyers tend to say, when the tenant was in arrears of rent. Judgment was given against him in the Epsom County Court on the 30th of October 96, and he sets out the terms of the order. Now the order is much closer to what it should have been, because it's very much in the form of N27, but the date for possession is wrong, which is the point which is made between letters D and E. The order was wrong. Section 1383 required that a period of not less than 4 weeks should elapse before the order for possession could take effect. Instead, it was an order for possession on the very day it was made, unless the amount due was paid. We don't know how an order came to be made in that form. And the issues are then, I think I should draw your attention to something which is said on page 325 between D and E. Because the case is largely about the position of the creditors. But it says the second issue, whether there are grounds for setting aside the judgment given in the absence of the creditors, depends, and then there's an irrelevant point to this appeal. It says, and then at E, it says, alternatively, should the judgment be set aside on the ground it was irregular in the way already stated? And that's the reference to it being in the wrong form. And again, there's then a long passage, of course, which isn't relevant dealing with the position of creditors, but you then get to page 331.
Was the order enforced? Do we know? We know the landlord applied to close the title at the land registry. I don't think we can tell, can we? Three two two E to F. The creditors didn't know about the order. They heard of it when there was an application to close the title.
Yes, that doesn't necessarily tell you as to whether they
No, it
executed.
doesn't.
Because I think to close title, you have to send the registry a copy of the.
Forfeiture order.
Yeah.
So they do it even before the 6 months is up, which is curious, but there we are. That's what they do.
Well, I have certain issues with the way the registry deals with this. In my submission, they shouldn't. The practice, certainly what they shouldn't do is close title while time is running under 1383, because what the practice guide says is there has to be an unconditional order for forfeiture, or presumably if the time for complying has expired, it would be good enough.
I mean, I asked that because at 325B, Sir Christopher notes that there was no application for relief within the 6 months allowed by 13890. So this is all happening after the 6 months.
Well, if 1389A was in point, then logically it must have been enforced, or possession taken somehow.
Yeah.
But we don't know as your lordship says, we don't know exactly what the position is. But yes, if that is right, then they must have taken possession.
Yeah.
What I was going to take your lordships to is what is said on page 331, final paragraph below letter G. Sir Christopher Staunton says there's another route by which the creditors can, in my opinion, have the order for possession set aside. It was defective. Instead of allowing 4 weeks, it allowed no time at all. It's true it may have been a slip. It's also true in all probability nothing would have happened differently if it had said 30th of November instead of 30th of October, but those who live by the sword shall die by the sword. The same applies to those who live by the rules. The court have no jurisdiction to make such an order. Creditors are entitled to have it set aside. The landlords may apply for a new order, but the creditors now know of the proceedings and they may apply for relief against forfeiture.
It doesn't look as though Spurgeon's was cited.
It doesn't, which is in a sense interesting because it means that a court of appeal which wasn't actually told of a case on almost the same facts came to exactly the same conclusion. At the very end of the judgment, there's also a on the very last paragraph, Lady Justice Butler Stoss agrees with Sir Christopher Staunton. Says the creditors shouldn't be deprived of the ability to seek relief from forfeiture. Sorry, grateful to Malone Jr. who's still Sadiq. He points out to me that if you look at page 320 in the head note, sorry, it's part of the argument, between letters B and C, it says that Mr. Tevison, who was arguing it, said that more than 6 months had passed since the landlord recovered possession.
I'm sorry, I didn't get the reference to that.
It's between letters B and C on page 320.
Thank you.
In the argument of counsel for the creditors. So that might be important because it does show that even if possession has been obtained, it's not a bar to the point which I am taking. The order is wrong. There is an entitlement to set it aside.
Yes.
Having taken that point, that is the independent point on ground one. Obtaining the set-aside and the order being remade in the right form, which might be the logical conclusion of that, is itself success. It may or may not be necessary to say that that is a form of obtaining relief from forfeiture and that relief from forfeiture is a defence. The way I put it was it's a slightly different point. Success must, if the purpose of CPR 55 and the return day is to obtain possession, then if you succeed in getting the order which was made on the day set aside completely and replaced by an order which doesn't give immediate possession and gives 4 weeks to pay, because that's what section 138 requires, that must be success within the meaning of CPR 39.35C, given that it's being applied by analogy only in the context of CPR 55. And that it comes out of Findlay, because in Findlay the point is whether a suspension under section 85 of the Housing Act to get you back in, whether that's success, and they said yes it is. This must, in my submission, count as success, and it would restore the lease. And I would be surprised, it's very difficult, I would submit, to see how that's not success for the purposes of setting aside the order if CPR 39.53 applies by analogy.
So I'm just trying to see what's happened here. Get back to section 138. So, if the order is set aside as of right, we have to analyse it. It makes a difference if it's a nullity or not. Let's assume that the original order of possession is set aside as of right. We're now under 138.3
3.
at this point.
Yes. What 1382 must be spent because there was a return date.
Yes. So it's not ceased under subsection 2. There was a trial. At that trial, the court was satisfied. It was in the trial.
Yes.
The undefended list, possession list is a trial. At that stage, the court was satisfied. The court had to make an order for possession, but it didn't do so in the right form. So on this assumption, it's not made an order for possession.
No.
And so you say that the position is that the lease is always, well, there's not a new lease, is there? It's the existing lease anyway. This isn't a case where the lease has been surrendered or anything like that.
The lease would go back into what's sometimes called limbo, because technically speaking, the forfeiture is affected by re-entry. The service of the claim is the constructive re-entry, and the order of the court at the end makes good the constructive re-entry. So, setting aside the order, sorry, my Lord, you do have to bear with me, and Lord Justice Lewison will correct me if I'm wrong about this, but it has a shadowy, odd existence.
Okay, first of all, this isn't a case. The lease, as I understand it, was passed on to the landlord's daughter. Has been sold on. Is that wrong?
No. What appears to have happened, according to the landlord's evidence, is that a lease was granted as a
new
gift.
A new lease was created
as a gift
right.
on the 17th of October, which was well within the 6-month period. And as my learned friend accepts, his client, it's in his own witness statement, his client actually knew that there was a 6-month period. And the court.
But let's get too involved in that.
So,
I wanted to know. So the answer is a new lease has been created.
yes.
And that creates an estate in the land.
Yes.
So that's not a nullity. The landlord has created, well, whether it's a concurrent lease or reversion lease or whatever, we can ignore that for the moment. Just want to see what the situation is. So there's that lease which is sitting there at the moment vested in somebody.
Yes.
On this basis, re-entry has been effected, but it's not re-entry pursuant to a valid court order. Is that right?
No, on this hypothesis, there wouldn't have been, the re-entry would remain the service of proceedings, because that's the appellant's case. The appellant's case is forfeit by service of proceedings, not by the grant of the subsequent lease to the daughter. So
it's not the one, it's the other. I mean, the reality is, if we can grasp the reality rather than just the legal principle, the reality is there's somebody else in possession there.
There is someone else in occupation.
Well,
yes.
I don't know about the possession occupation. There's somebody else there
yes.
exercising exclusive control over it.
Yes.
All right. So there's somebody else there. So I'm not sure whether we need to get hung up about when the re-entry is. There has been a re-entry, in fact.
In very colloquial terms, yes. I don't want to concede that there's, because re-entry is a phrase which has a lot of baggage attached to it, and if you have the only way which forfeiture can be properly sort of kept within the confines of logic and reason is to follow it through. The appellant's case is this. The appellant's case is that it forfeit the lease by service of proceedings. If what happens is that the possession order is either found to be a nullity or discharged, etc., then they're still relying on the original service of the claim form as being the act of forfeiture. In that circumstance, the grant of the subsequent lease is almost neither here nor there. There is another interest in land. It might take effect as a possessory title, as in a title in which it has the right of possession. Equally, as your lordship says, it might end up being a lease which is granted concurrently because it's second in time. And there are quite complicated issues about which of the two leases would grant the right of possession, which are not issues, happily, which are before this court. But coming right back to what's the status of my client's lease? The answer I submit is that my client's lease effectively goes back to what's called the limbo period, because there's been the constructive act of re-entry by service of proceedings, but there isn't a court order which completes the circle to say that the lease is forfeit.
If, on the other hand, there had been no service of proceedings, which I think is one of the things you might wish to argue if this goes back, then the physical entry in August would have amounted to a forfeiture, would it not? Because the landlord had the determination of the FTT. I think at some point there seems to have been a money judgment in the Bromley County Court. I don't think we've seen that.
I've never seen it if there is one.
So all the statutory hurdles have been jumped. There was nobody living in the flat, so the restrictions and the Protection of Eviction Act applied. So the landlords would have been entitled lawfully to take possession on the ground of the arrears.
Subject to 2 points. I appreciate that. That's how Gibbs, one of the things which was said in Gibbs. There are 2 points. The first is, in effect, that depends on whether or not it was, whether or not there was valid service. The learned friend isn't in a position, in effect, to approbate and reprobate.
Yeah.
If we were to pursue the point, then one can see that line based on the Gibbs case, and one might have to take a view as to whether or not that was a very good idea for my client to run that line. But there is a second problem with that analysis. And the second problem with that analysis is that there was a clear act of waiver, we say, by serving the notice, going into the flats to inspect, changing the locks for the purposes of inspection, and the notice is unequivocal. Now, if that was an act of waiver, then it wouldn't have been lawful to forfeit the lease by peaceable re-entry, because there wouldn't have been any unwaived rent arrears or service charge, which was the subject of the determination. And so that might be the answer.
I only wanted to ask a very simple question, really. All I was trying to do was to find out whether it makes the slightest difference, whether as to the existence of the original lease, whether or not the order was a nullity or not a nullity. That's all I wanted to know. And that's why I was trying to follow through.
Probably for the purpose.
I don't think it. I think it doesn't make any difference for this.
For that question, no, I don't.
It doesn't make, because I mean, since we haven't done the wider research on the question of what is the effect of the order, where it's not one within the jurisdiction of the county court to make. I totally see the logic of the point of saying it has no inherent jurisdiction. It is a nullity, whatever. And I think myself, I'm a little bit nervous to jump into that without making sure there isn't some other authority on the point. So I'm just trying to work out from the purpose of this case whether it makes any difference, because at the end of the day what you want to know is what's the status of your lease.
Yes, okay.
And I don't that's all I wanted to know. And I don't actually think it makes any difference to the analysis here.
For the purposes of that question, I agree with you, my lord, it doesn't, because it doesn't matter why. For the purpose of the narrow question which your lordship asked, it probably doesn't make any difference, because one way or another, if the possession order goes, you haven't completed the circle of
if it's a nullity, you're plainly right in saying that section 1383 hasn't been complied with.
Yes.
And if the forfeiture was intended to be by the issue of the proceedings, that, as you say, is in limbo, it's not been completed. Similarly, what I want to know was, if you apply to set it aside, what I'm trying to get is, if you set it aside, what's the position then as regards the lease? And it seems to me that it's set aside, that although it's not set aside until you do make your application. At the moment, once you set it aside, it's set aside ab initio, and that
Yes.
does seem to be the effect of Spurgeon.
Yes, and you could
You
also
set
look
it
at-
aside ab initio because you can't sort of retrospectively have a new order from that date.
that's right, my lord. Yes,
So-
either way it goes. Either way.
It makes no difference on this case.
Yes, on the question your lordship asked as to the status of my client's lease, either
Yes.
way, my client's lease would go back into what would be called the limbo period,
Yes.
and it could then only be brought to an end by a fresh order.
So I think what this means is, I'm sorry to be very laborious and slow about it, but I think what this means is to complete your submissions, as it were, on the Spurgeon case, you would say, even if it's not a nullity in the sense we understand it, that you can simply completely ignore it, the fact of the matter is that once you do apply for it, it is discharged ab initio. I
Yes.
think that's what you have to, that's
Yes.
the kind of final piece.
At worst, from my point of view, the order is entirely irregular because it was made
Yes.
without jurisdiction. There is a right to have it set aside.
It's discharged ab initio.
Discharge
And
ab
then-
initio, so it never had
Yes.
any effect.
Yes.
So the lease was not terminated by forfeiture by that
Yes.
order.
And it's never been said in this case that, as I understand it, that the re-entry or the going in to have a look and changing the locks was an entry to complete a forfeiture. It wasn't re-entry. It was re-entry for a different purpose.
No,
And you've said expressly that what the landlord's relying on as the re-entry was in the normal way, the service of the proceedings
yes.
after a forfeiture having been incurred.
Yes, the landlord brought a forfeiture claim on because
Yeah.
after
We don't have to worry about them re-entering, as it were, pursuant to that claimed entitlement to inspect, you say.
No, on the contrary, that
Yeah, you say it's a waiver, I don't understand that.
yes, the
No.
landlord was relying on the lease, and afterwards they served 146 notices
Yes.
and then issued proceedings, and then obtained the order. And their case up to this point has always been that they forfeit by proceedings and the
Yeah.
court order.
Yeah.
And indeed,
But all the interesting arguments that you were discussing with Lord Justice Lewis about, which again was what I was sort of trying to understand about what affects the forfeiture, is that if it's argued that it lies in the future, if we were otherwise with you on the jurisdiction point, it would then be a matter for future argument elsewhere as to whether or what the consequence was in terms of forfeiture, if there was, and whether there was a re-entry by a physical re-entry later. That's all for the future. We don't have to worry about that here.
I suspect that your lordships don't have to worry about it. I think that the point is, from my perspective, in a sense, I do come back to the point that what my client won below, and what should happen here is that the appeal should be dismissed on the basis that the order is a nullity or at worst irregular, and it goes back to the district judge on the set-aside application. And I suggested that the judgment of this court would provide a very clear steer to the district judge as to how to proceed. But the answer is it ought to end up set aside. What happens after that? There are all sorts of, because I know my learned friend wants to
I
argue
think that's
about
what I'm saying.
Yes. So
I'm saying, I mean, we would say, because I don't seem to understand that at the moment, I'm speaking only for myself here, if we were to decide that on the basis of Spurgeon Holmes, it was either a nullity or irregular, and should be set aside, then, I mean, we would say that.
you would.
We would say that. But even so, all these other matters about what was the re-entry, was there a subsequent re-entry, not by issue of proceedings, but actually that was overtaken by a physical re-entry and a grant of a new lease, and was that a peaceable re-entry, was it lawful or was it not lawful, because there was nobody living there. That's all for the future. We don't have to get involved in that.
I would submit, no, you wouldn't. And the first thing which would have to happen would be my learned friend or his client would actually have to raise it. I mean, I can see why my Lord Justice Lewis might make the point, because of course you can see it in Gibbs and Lakeside, but it's not, of course, what the appellant is saying in this case. And as I've pointed out, there are distinct problems with the appellant trying to change position.
But
And
it's not an issue on this appeal.
no.
Could you just, for my benefit, just complete the sentence you were about to complete, saying that you know my learned friend your learned friend is going to argue ...
Oh, I think that what he wants to argue that that the position of the lessee should be taken into account because his client granted what I say is precipitately that.
Got it. No, I understand. Thank you. I just wondered something else that you thought you were
So
interested.
that's your case, is it on ground one?
That is my case on the separate ground one.
Do you want to ask?
No.
Yes, thank you. Now, would you like to address those points, Mr. Simmons?
Yes, my lord. My lord, the starting point is on the interpretation of section 1383.
Yes.
And the first aspect I'd raise is on the authority of Gibbs, quoting Lord Justice Parker, Lord Justice Lewison said at paragraph 55, in my view, there's a clear statement that in the case of covenant between lessor and lessee, relief against forfeiture is now regulated wholly and exclusively by statute. I can attribute...
Which is the tab? Can you just take it to the tab?
That's at tab
29.
29,
Which paragraph?
and it's paragraph 55.
Yes.
So,
Well, actually, it's paragraph 47, I think, is the quotation of Justice Parker.
Yes.
yes, I apologise, my lord. So, whereas it is...
Where does that get you there?
Well, what that gets us is that though reference can be made back to the earlier statutes and relief from forfeiture as an equitable remedy, at the end of the day, that cannot undermine or distract from the starting point, which is the interpretation of the existing statutory provisions and giving 1382 and 1383 their natural meaning. 1383 states clearly that if the action does not cease under subsection 2 and the court at the trial is satisfied that the lessor is entitled to enforce the right of re-entry or forfeiture, then the court shall make the order for possession and it won't be less than 4 weeks. But that is quite clear on its clear provision that that applies if the court reaches that conclusion at trial. Now, it's conceded by...
In 1984, when this Act was passed, what was there in the county court to determine claims for forfeiture for non-payment of rent, other than a trial?
My lord, that's right, that in 1984 there would either have been trial or there would have been summary judgment. And my lord, this is something that has bothered me, and if I may, I've passed this morning to my learned friend. It only occurred last night, but I have here, if I may pass it up.
So this is Order 23, I think, wasn't it?
This is, yes, it's the relevant Part 9, County Court Rules 1981, Admission, Defence, Counterclaim and Answer, and Part 9, Rule 14, which imports Order 14 of the Supreme Court rules. If I may. Yes, can you see?
I have a vague memory of something called Order 23 in the county court, the summary judgment procedure. So, just to see where the roadmap is, you say, well, you can pay in before 5 days before the return date, that's one.
Yes.
If the matter goes to a full-blown trial, you get an order under 1383. But if it's disposed of in a way that doesn't involve a trial, then what? You're not entitled to relief at all?
Then,
Or is it in the discretion of the court?
then in my submission, you're not actually entitled to relief at all. There is a lacuna there.
Could there be a rational reason for passing legislation with that hole in it?
A mistake on the part of Parliament or not addressing it. I mean, if one looks at the history of this, 1389A, the 6-month provision, was originally included under the County Courts Act 59. They then brought out the County Courts Act 1984, totally left out that provision, and within about a year brought in 9A. So one of the things which may be uncomfortable to say is that Parliament has made a mistake, or that this has not been covered off.
Well,
And
it's a bold submission.
indeed, my lord, but the support of that is that under Order 14, which is imported to the summary judgment procedure where there's no real defence in the county court rules, it says at 10, relief against forfeiture, a tenant shall have the same right to apply for relief against judgment for possession of land on the ground of forfeiture for non-payment of rent has been given under this order as if the judgment had been given after trial. So if there wasn't a need to determine that a summary judgment application, which was in effect the pre-CPR position, if there wasn't a need to say that a summary judgment order was the same as a trial, then Order 14, Rule 10 would be entirely otiose. They had identified under the old rules, in my submission, the problem, which was that you produced a lacuna under the County Courts Act if you didn't deem that to be a trial, and therefore that supports the proposition that without such a deeming provision within the rules, it is not a trial.
So where does the county court's jurisdiction to grant relief come from? How can the rules give it a jurisdiction which it doesn't otherwise have?
My lord, the unfortunate position I have to argue, but it does follow from the true construction, is that where a landlord has proceeded and the tenant hasn't defended the matter, and the tenant hasn't taken the opportunity they had prior to the hearing, then there is no jurisdiction for relief.
Yeah, but there wasn't ever on your argument, as I understand it, because you say, I think this is right, county court can only do what the statute says it can do. It doesn't have an inherent jurisdiction to do anything. That's one of the points that comes out of Gibbs. Section 138 doesn't give the county court the power to grant relief except at a trial, and that means a contested proceeding. Therefore, you say, the county court has no jurisdiction under the statute to grant relief if the claim is disposed of otherwise than by trial, in which case my question is, then what right does the Rules Committee have to confer that jurisdiction on the county court, which Parliament has excluded?
Well, my lord, because it is in effect the Rules Committee which sets out the basis upon which matters are either dealt with summarily or at a full trial, they have, within the scope of those rules, or previously, deemed a summary judgment application to be a trial for the purposes of relief from forfeiture. So this situation would not have arisen under the old rules because of the importation of Order 14 and Rule 10, which dealt with this very point. That, for whatever reason, does not seem to be picked up by the Rules Committee when the CPR came into force, and Part 55.8, which allowed for a summary procedure, which my learned friend concedes, and the authorities are clear, is not a trial. And then when one then turns to look at...
Sorry, what was that about the concession? It's not a trial?
It's conceded my learned friend's argument that on the authorities, an order for possession under CPR 55.8 is not a trial.
That's Forsyth and Binney.
Yes.
Not a trial for the purposes of the CPR.
Yeah, 39.
Yeah, that's a different issue entirely.
Well,
But, sorry, can we just get back? The mistake, if there must have been a mistake, as you say, can't possibly be in relation to the rules. It must be a mistake in the drafting of section 138. Because the word trial in 1383 must bear the meaning intended by the legislature, irrespective of what anybody else says it may mean. Very often you'll get, as you know, statutes which say there may be the rules may prescribe X or Y, and thereby amplify what's in the statute. There's nothing in section 138, and you haven't shown us anything anywhere else, which says that trial is to bear the meaning that the Civil Procedure Rule Committee, then it would be the Supreme Court Rule Committee, decides. So we have to understand the meaning of the word trial in section 138 from examining the statutory provisions and what it's intended to be aimed at. Sorry, this was my Lord's point. I mean, that must be right, mustn't it?
my lord,
A rule-making body, which isn't even a rule-making body set under the 1984 Act, cannot possibly determine as a matter of law what is or what isn't a trial for the purpose of the Act. So I think what you have to say, at the moment it seems to me, is that the parliamentary drafter got it wrong.
my lord, yes.
And that's what you do say.
That is
I think this excursion into the Supreme Court rules, I don't actually think helps particularly. I may be wrong about that. That's my current view. But you have to say, and you do say, that the parliamentary drafter got it wrong because by referring to a trial, the drafter was thereby excluding anything that was not a trial, even if it resulted in a court order for possession. That's what you do say.
and my lord, if I could ask you to turn to Forsell and Binney, where it was dealt with. It's at tab 7 and paragraph 45 on page 350.
Let me just see what the case is about.
Right, so I read this. Yes, Forsell and Binney. Yes. Forsell Lux and Binney.
And my lord, this
Which paragraph, sorry?
is paragraph 45.
Yes.
And my lord, Lord Justice Parker identified the problem himself. He says, now it may be correct.
I think this is Mr. Justice Warren, actually.
Sorry, Mr. Justice Warren. Said, now it may be correct, I do not decide the point, that relief could not be given under subsections 9A unless there is a trial within the meaning of subsection 3. But the point which is being made only creates a problem if trial is to be given the same meaning in section 138 as is given in 39.3. I do not see why that word should carry the same meaning in section 138 as it has in rule 39.3. Consider the example of a hearing of a summary judgment application under part 24. such a hearing is not a trial, see Rule 24.1, before the introduction of Part 55, a claim for possession could have been the subject matter of a summary judgment application with certain exceptions set out in Rule 24.32. That remains the case today, albeit that a Part 24 is not likely to be invoked since the Part 55 procedure in effect provides, as I see it, a similar summary remedy. The judge at first hearing will be able to decide the case just as speedily and effectively as he would on a Part 24 application. It seems to me unlikely that Parliament can have intended that relief under Section 1389A should be available where the possession order was obtained at trial but not on a summary judgment application. So one can see that trial does not need to have the same meaning in both contexts.
That's against you.
That's
It-
against you.
It is, but what Mr. Just Warren hadn't been either addressed on or does not mention is that under the old County Courts Act provisions, Order 14 was imported
Yeah, and there was an expression.
to expressly make. And so if it was so cut and dry as he's stating here, that it's a different type of, it is a trial for the purposes of Section 138, which isn't in itself supported by any authority, it's just his examination of the matter, and in any event is made obiter. But he didn't address the fact that the Rules Committee had previously identified the same problems and had actually given an answer to that problem, which is that they deemed a summary judgment to be a trial for the purposes of relief from forfeiture.
Yeah, but for the purpose of the rule. Anyway, are you? Is it? I understand the submission that the drafter got it wrong, the parliamentary drafter. That I understand the submission, so I agree with it. And we've heard the submissions on that. It provides, if he got it wrong, if she or she got it wrong, it provides a lacuna in the statutory scheme. Is your submission also that the rules of the Supreme that the rules of the Supreme Court and now the CPR, civil procedure rules, can determine what is a trial for the purpose of Section 1384? Is that 1383? Is that your submission?
My Lord, not quite as my Lord puts it. This isn't, the County Court Act is not a completely separate act on its own terms. It is there to govern the provisions and the powers of the County Court. And in terms of almost a chicken and egg situation, when it's being drafted, you have the County Court rules and you have the County Court Act, that at the time of it being drafted, they would have been aware of the summary procedure within the County Court, and they would have been aware of the trial procedure within the County Court. They make a distinction in Section 1382 between return day and Section 1383 being trial. And this is an order made under CPR 55 on the return day. They could have quite easily have sidestepped this if it was their intention that the summary procedure was also to be a trial within the meaning of Section 138 by referring to return day and trial or return day summary procedure and trial. At the time of it being drafted, in 1984, summary judgment was a well-known procedure. It wouldn't have been alien to those drafting the County Court Act, which was specifically concerned with the jurisdiction of the court and the way in which court procedures were undertaken. So it is.
So what it comes down to this, I'm trying to work my way through these submissions. So this submission is an interpretation point based upon two things. One is the difference between return date and return day in 1382 and trial in 1383. That's the first thing.
Yes.
And the second thing is that at the date of this Act in 1984, under the, I think you're saying, under the relevant county court rules, it was recognised that a summary judgment hearing would not necessarily be a trial unless it was deemed to be. Is that the point?
By importing Order 14, that yes, it was deemed by Order 14 to be a trial for the purposes of relief from forfeiture. And so I ask rhetorically, why would the rules deem it to be a trial if it didn't need to deem it to be a trial? And it specifically deals with relief from forfeiture.
What was the nature of the beast when the absolute possession order was made? What sort of proceeding was it? You say it wasn't a trial. What was it?
It was a summary procedure.
It wasn't an application for summary judgment, though, was it?
No, because under CPR 55, point 8, the court can
So you have
deal with it there and then.
You're saying then there are three types of county court determinations. There's a trial, there's a summary procedure, or somewhere in between the two, an Order 55 return day hearing.
Well, I wouldn't
Which is
characterise it as being between the two, but it is a
It is not,
third.
whatever else, it isn't a trial.
Indeed. And Mr. Justice Warren, in the passage I just quoted, identified the three different procedures.
Well, he did, but all he's saying is he's only concerned with what the trial means in the rules. He says it may or may not mean the same thing as Section 138. He doesn't have to decide that point.
Yes, but here the court does need to decide that point in terms of
No, I know, but
whether
I don't see how you get any help from it. He specifically decides he's not deciding the question of whether trial in the CPR means the same as trial in Section 138.
but he does pass comment. And the comment he passes doesn't actually support my position,
No.
but I give the reason
Well, I
via.
think you've explained. So I think I've understood the second. So the second rather complicated is that under the CPR rules, the County Court rules at the time of the County Courts Act, 1984, contained a provision importing Order 14.
Yes.
And the provisions under Order 14 contain this provision, 14 and 10 or something, which says that a tenant shall have the same right to apply for relief after the judgment possession of land as if the judgment did not trial.
Yes.
And therefore it acknowledges that it's acknowledging that summary procedure is not a trial.
Yes.
And therefore the drafter would have known that under the current practice, a trial did not include a summary procedure.
Yes.
All right, I've understood. Yes.
And that
Do
was.
you recall offhand what the Common Law Procedure Act said? Because Order 14 would have been concerned with the High Court, to which obviously Section 138 is not applied. So its primary purpose would have been connected, I guess, with either the Common Law Procedure Act or the general inherent jurisdiction to grant relief against forfeiture.
My Lord, I'm afraid I don't. As I say, this point occurred to me
Yeah.
yesterday evening, and what I've tried to establish is why that would have been required in the High Court. But given that we're in the County Court, the fact it's been imported into the County Court
Yes.
makes the point.
Any other point on the ground one respondents?
Yes, my Lord, very briefly. In terms of also what the intention was, if someone is properly served with the proceedings and they have no defence, and there could be a genuine defence, my learned friend raised questions of waiver, service, etc., all of which would be substantive defences. But if someone has no defence and they've been properly served, then they are given the provision by 1382 to avoid the forfeiture before the proceedings commence. However, if someone believed themselves to have a defence, then clearly they wouldn't go and pay in and avail themselves of 1382, because that would then stop the proceedings and not enable them to put forward what may be a valid defence. In those circumstances, if one then goes and proceeds to a trial and it's determined that they do have a valid defence and it goes to a trial and then the court finds against them on that defence, then they're given exactly the same opportunity again by section 1383 in order to avoid a forfeiture or any possession action. Because of course 1389A takes place after possession has been achieved, so the tenant would have been ousted from their premises. So there is a reason why there would be that distinction between the return date, where it could be dealt with, and a trial, where it is then dealt with after full argument, giving them a repeat opportunity. That also has to be seen in the context of section 139. And here, if the landlord had elected to take peaceable re-entry...
Sorry, what's 139? You mean 1389A?
So, no, section 139 of the County Courts Act.
Right. Have you got that? Have you got that?
It's- sorry, my lord, I'm afraid we haven't provided a copy of section 139.
Can I just, it's very important I understand, before you go to 139, can I go on to this, just to, again, I'm trying to put in my own language what you were just saying about this point about whether somebody's got a defence or hasn't got a defence. So you say, well, if somebody hasn't got a defence, it'll go onto the return date and there'll be an order.
Yes.
And are you saying that they shouldn't, it's not surprising in those circumstances so they don't pay the money into court, but they don't think they've got a defence, so they don't put in a defence, and so it then goes to whatever the hearing is, and there's an order made against them. And I think you're saying it's not surprising that in those circumstances they don't have any opportunity for relief from forfeiture. Your second point is, well, if, as I understand it, if somebody thinks they have got a defence, it will go to trial, and then they'll have the opportunity of getting relief from forfeiture in accordance with the Act. Is that the point you're making?
Yes, because if somebody had a defence, that they wouldn't avail themselves of section 1382.
What happens if they're not around at the time, or they're ill, or something like that? What happens if they only hear about the proceedings later on? I mean, there may be a million and one reasons why somebody does have a defence, but may not put in a defence at that particular time. Maybe they haven't got any legal advice. They don't know what their rights are.
Then that would be dealt with by the set-aside provisions, because they would have a genuine defence. They would be arguing that there was a waiver, or they'd be arguing that in fact a determination hadn't been made, or whatever reason there might be. They would be arguing that hadn't been service. All the arguments, the additional arguments that my learned friend was making, which they'd made originally, could have been genuine defences.
So does this point come down to this? That if somebody, it's as simple as this, if there's somebody who doesn't put in a defence, there's somebody who doesn't defend, it's either, you say, because they haven't got a defence, in which case they shouldn't have relief from forfeiture anyway, and if they do have a defence, but for whatever reason they haven't actually taken active steps to defend, then it's not surprising that the drafter doesn't give them a statutory right, but their right is pursuant to rules of court, which enable them to say it's unfair that the original order should stand. Is that what it comes to?
In effect, yes.
So a tenant is sued for non-payment of rent and needs to be forfeited, hasn't got a defence, turns up on the hearing day under Part 55 and says, Judge, I haven't got a defence, but I can't pay pay within 4 weeks, can I please have 8? Does the judge have power to do that or not?
They could adjourn the proceedings.
Does the judge have power to give relief against forfeiture on payment of the arrears within 8 weeks or not?
My lord, as drafted, not.
Not.
But then that also, then, if one accepts that there's been a mistake in the drafting, then comes the question of whether the further provisions which are made subsequent to section 1383 are excluded or not. So all the further
Further provisions.
1387, 1389A refers.
9A may or may not be excluded, but 7 and all the rest of those depend on there having been an order made under 1383.
Yes.
And your argument is that we don't get to 1383 because this is not a trial. So if we don't get to 1383, then subsection 4 can't apply because it's only extending the period under an order made under subsection 3. 7 doesn't apply because there never has been an order. And probably time doesn't start to run under 9A because there hasn't been an order under 1383.
My lord, those are
all consequences.
those are all possible consequences of the mistake. But for the purposes of today's hearing, what I'm seeking to establish in terms of the statutory provision is that actually the order that was made was not irregular, it was a proper order. As to the consequences,
Because it wasn't made under section 138.
because it wasn't made under 1383. As for the consequences, my lord, I could come up with all sorts of interpretations, but given that the mistake is there,
So which mistake?
the mistake in saying that 1383 was limited to trial.
So pursuant to what
You
power-
think the drafter did make a mistake then?
Either they made a mistake or they intended that, but I can't submit why or how that then manifests itself going on. And my lord, it is a very bold submission to make, but it was within a year that they were bringing in 1389A. 1389A should really have been in the Act from the outset. And I come back again to the Order 14 point.
If it wasn't an order made under 1383 that was proper, pursuant to what power was it made?
By the common law right to forfeit based upon the terms of the lease.
So not under section 138.
So
It would be simply
just a contractual right to forfeit the lease. The County Courts Act imposes a restriction on that, but it doesn't change the fundamentals. And my lord, in Croydon, one of the points made is that if you use the rules as a sword, then they'll be used against you as well. The fact is that the point has been made at this 11th hour that the original order is a nullity. And so if that is relying purely upon the technicalities, then I rely upon the technicalities as well. And if one looks at actually the purpose of this and the fact that this is a technical way of getting a second bite at the cherry, because if the order had said 4 weeks, we would have been the respondent would have been in exactly the same position. Now, in Croydon, the court passed over that. It's not clear whether Croydon is actually obiter or not. It doesn't say the basis upon which it's set aside. It raises 2 options, but doesn't say we're setting it aside based upon the irregularity point. But here, the prejudice is entirely against the landlord. It's raised as if there's some sort of criticism that a landlord goes off and grants a new lease. Well, under section 1389A, they're entitled to do that. They, as long as they
Yes,
know
but you
that.
do it, yes, but you do it at a risk, because you know that under the provisions there, there's a further period of time.
Absolutely, my lord. And the landlord.
So there's a risk that you take. That's the only point.
And my lord, the appellant accepts the risk and accepted the risk under 1389A. What they didn't believe that they were under risk was a situation where there was no discretion of the court that was undertaken, but that there was an automatic relief from forfeiture, which is the situation under 1383 if the tenant pays within the first month. And that's what's behind this. At the time that the application for set-aside was made, they could have gone under section 1389A. They were in time to go under section 1389A. The whole root of this is that in circumstances where not using it in the strict sense of abandonment in terms of a surrender, but in a more colloquial terms of abandonment, the tenant had abandoned her flat. And in those circumstances, they would, rather than going down 1389A, where the court would have the discretion and could balance all the factors, they're going for this mandatory procedure. They are trying to take the technical point. And that also has to be seen in the context of the finality of court orders and the fact that you had got 6 months. If the tenant was coming along and it was 3 weeks in, then there may be rather more power to that point if I'm wrong on the technical aspect. But this isn't. This is someone coming over 6 months later and trying to get a mandatory process rather than discretionary process.
So 6 months after what?
6 months after the possession, after the order and after the possession has been taken.
Yes, well, this is a good...
I thought that possession was taken in August and the application was made in January and the 6 months ran out in February. And you just said they were in time.
Yes, but rather than
They haven't waited more than 6 months for possession.
no, sorry, my lord. What I mean by that is that they were in time to make a section 1389A application, but not in time for this 1 month period.
Well, the 1 month period is a statutory minimum. It could have been more than a month, and it could have been extended from that time.
Indeed, my lord.
Yeah.
But then that also has to be looked at in the context of section 139, and my lords, I can on the lunch German I can get a copy of that.
We've got it in White Book Volume 2, page 1024.
I mean, your merits point, you make a very powerful kind of jury straight merits point about the effect of this clever lawyer's point that Mr. Rainey's dreamt up at the last minute, is that it takes away the issue of discretion that would have applied under section 1389A. But that can't affect the meaning of the Act. That's the difficulty. This point can't depend upon whether it's, it's a hard case, it's an easy case, it's unfair to your client or not. I mean, we can't be affected by that issue in deciding what the scheme of the Act is.
My lord,
It's not that we're hard-hearted, Mr. Smith, but that we have to apply the law at the end of the day.
no, absolutely, my lord, but the law applied within the circumstances of this case, because as my lord identified, and this comes to the question of a nullity and the line of authority saying that you can rely upon the order of a court until such time as it is set aside, and therefore, given that it's set aside, the question is whether the court is in all instances compelled to set it aside because it's irregular. So if you're not with me...
That's a different point you're introducing then. Now, are you saying that notwithstanding the case to which you've been referred, you don't have in this particular case, the tenant isn't entitled as of right to the set aside that it's all discretionary. That's a new point. You're saying it's all discretion,
My Lord,
whether you set it aside or not.
My Lord, in the Croydon case, it was raised as to whether or not this could be dealt with under the slip rule. And it was dismissed, but it was dismissed in that case because the one party had had absolutely no opportunity at all to make any representations, and it was there to facilitate the chargee to apply for relief from forfeiture. And there, part of the reasoning was, well, if you're relying upon the technical rules, then you should suffer the consequence of the technical rules. But in this instance, it has caused the tenant no real prejudice. A new lease has been created, so it creates a procedural mess.
I just want to interrupt you. The point I was making, trying to elicit what your case is. Are you saying that if you're wrong about the meaning of trial in section 1383, if you're wrong about that nonetheless the tenant does not have an entitlement as a right to have such an order set aside, but it's only a discretion. It only has a right to invoke a discretion on the court. Is that your submission?
Yes, my lord. Because, my lord, otherwise, in my submission, it makes a nonsense of the fact that a party may rely upon an order of the court until such time as it is set aside. So, in reliance upon what a party believes to be a valid order of the court has been made by the court, and they've not identified that it's not been made in the proper form, they then have, the land registry removes the former lease, a new lease is granted, and my lord has said, well, these are potentially future things to be looked at, but what it does is rather than deal with it today in toto, it actually creates yet another limb of argument between the parties as to what is the effect of the order being set aside at this stage.
But you've got no authority for that proposition.
I have no authority for that proposition.
I have in the back of my mind there is a case where a county court purported to contract out of security or tenure a business lease which was not within the relevant statute. And this court, what my memory is, had to consider what the effect of that order was, and the court had no power to make it. I'm afraid I can't remember what the outcome was, but I think there is such a case.
My lord, on the question of, and I'm afraid, my lord, I can't remember off the top of my head at the moment the name of the case, but the one in which the Home Secretary was found in contempt. Well, there, the court didn't turn around and say, well, regardless of the fact you're in contempt, the order should never have been made, therefore you get rid of the order ab initio, and therefore... But the principle, my lord, would be the same, that all orders of the court are to be respected until such time as they are set aside. And if that is the case, then it must follow that if somebody is entitled to act upon an order as if it is a valid order, the consequences of their actions must also be treated as valid and must be one of the factors that should be taken into account as to whether it is or is not discharged. If it has to be discharged before it ceases to have effect, then that's exercising a judicial function. And to look at it as if we're in some sort of how many angels can you get on a pinhead abstract and ignore the consequences of the fact that there is a new lease here would be entirely alien. Also, in the Gibbs case, though that was decided based upon the question of the failure to serve, what was being argued there was a claim in unjust enrichment. And so it may well be that the consequence is a claim in unjust enrichment rather than a claim that the actual possession order itself has to be set aside.
Right, I'm slightly concerned about the time. We're still on ground one of respondents' answers, and we're going to finish at 4:15 today. Can I suggest that you wrap up your submissions and we hear Mr. Rainey before 1 o'clock, and then we'll have to hear the rest of the case in the next 2¼ hours, and you'll have to discuss over the short adjournment how you're going to divide up that time. So would you like to complete your submissions now on this first point?
Certainly, my lord.
Do you
My
want
lord-
the first to 139?
My lord, 139,
Which page?
this is 1024.
102.
4.
Yes.
And it's subsection 2. It says, where a lessor has enforced against a lessee by re-entry without action a right of re-entry or forfeiture as respects any land for non-payment of rent, the lessee may, at any time within 6 months from the date on which the lessor re-entered, apply to the county court for relief, and on any such application the court may, if it thinks fit, grant to the lessee such relief as the High Court could have granted. Well, my lord, though this is 139, in terms of interpreting the provisions, and this goes back to my first point as to what is meant by the discretion and 138 and 138.2 and 138.3, is in this case the appellant could have affected and may well have affected peaceable re-entry. If they'd affected peaceable re-entry, because the respondent was abroad, she wouldn't have known about it. She would have had 6 months, and then after that 6-month period, if no application for relief had been made, that would be it. There would be finality. In this case, it's outlined by Mr. Harrington, or was outlined by Mr. Harrington in his witness statement at tab 10, page 205 of the hearing bundle, the core bundle.
Page 2 then.
5. With my learned friend Skeleton, he effectively alludes to the fact that the landlord's trying to steal, or the appellant was trying to steal a march by granting out the lease and the way in which the possession was proceeded with. Paragraph 12 to paragraph 16, Mr. Harrington, and this was in the witness statement which was attached to the original claim form for possession, describes what they're doing and why they're doing it. And that is that at paragraph 13, he says the claimant is entitled to seek possession and forfeit the lease by peaceable re-entry on the basis the landlord has reasonable belief that leaseholder has stopped occupying the premises for the purposes of its residence. Then 14, this does not appear to be a temporary absence from the property on the basis of the information which has been provided. However, I believe in order to protect the claimant from any potential sanctions for taking possession under the provisions of the terms of the lease by way of peaceable re-entry, it's important that the court's order is obtained to confirm that the claimant has the right to seek forfeiture of the property. My Lord, in my submission, it should not be, the court's attention should not be lost on the fact that we are dealing with a particular circumstance here that arises, where, in effect, a tenant is absent or has abandoned their property. If the tenant was in the property, then the landlord's never going to get possession without them knowing that they've got an order and knowing that they can then apply for relief on that order. The landlord here, the appellant, could have proceeded under section 139.
Yes, but it's all for the future as to whether they give the proper service on the right address in the right way. We can't, that's all bound up with that whole issue. The complaint that's made against them is you didn't properly draw this to the attention of the tenant or the people acting for the tenant. Well, we're not going to go into that, and the you know, you said we're not going to hear that on this appeal.
Yes, my lord, but the point...
Because you describe it as she's abandoned it, as though she wasn't interested in any way in what was happening. But her case is, well, she was interested in what was happening. There were people on the ground who could deal with it, but there wasn't the proper service. We can't determine that. That's an issue between the parties.
My lord, save that the point as to non-service does arise in terms of, if you're with me, that the court does have a discretion as to whether or not to...
You would have to go to- Anyway, you've made your point.
Yes.
Anything
My lord,
further?
unless I can be of any further
Thank you
assistance.
very much. Yes, Mr. Bain, do you want to do a recovery?
Most of it is simply it's points I've already dealt with in my skeleton argument. You're right. The key point is that it's a matter of construction of Section 138 and what the word trial means. I mean, that's the nub, as I understand it, of my learned friend's response to Spurgeon's Homes and so on. And I do, for the reasons I've set out in my supplemental skeleton, simply say he's wrong. There isn't a definition there isn't a particular definition of trial in the County Courts Act, whereas there was a definition of return date. And the trial is one of those words which everybody uses all the time in the law, but it doesn't have a fixed meaning.
What it says, whatever happens after the return date stated on the summons, which finally determines
Exactly.
the action.
So, yeah, indeed. So it could be if it's undefended, that's an undefended trial in effect on the return date, or it could be in theory, a 4-day trial on the merits 18 months later after directions, but they're both a trial. And 138 is clearly based on that proposition. But I've made that point already. Dealing with new points, that reading the material on Order 14 and so on, that with respect to my submission, my learned friend's making a mistake, because if you look at the second page of his extract, which is Order 9, Rule 14. So the second page of the extract is the form of Order 9, Rule 14, which was in force at the date the County Courts Act 1984 was brought in force from January the 1st, 1983. Do you have that, my lord?
Yes.
First line, without prejudice to Rule 11 and Order 13, Rule 5, wherein a default action.
Yeah.
It didn't apply to fixed date actions at all. So at the time that Section 138 was brought in, you couldn't get summary judgment in the county court for possession of land.
So what's the default? What is a default action?
A default action was the default form of action, which was anything where there wasn't a fixed date. But without going into all the technicalities, possession of land was always a fixed date action, and the two had entirely different meanings. So you simply couldn't have summary judgment in the county court for possession of land. So all of this point about the county court rules is wrong.
Which bit of the rule were you reading? Sorry, it was 14.
14.1.
1.
Where in a default action dates is some.
It's the second page of Millennium Friends extract.
Wrong. I do apologise. Yes, I see.
It's actually Order 9, Rule 14 in the county court.
Sorry, Michael.
And that was only changed in the rule was changed in 1990, which is the next page, which extended it to any action except B, an action for possession of land.
Just catching up now.
Sorry, I'm going too quickly.
Where are we looking at now?
If you turn to the next
Summary
page,
judgment where no real defence. Is that
Yes.
the point?
that's the version which came into force on February the 5th of 1990. It extended summary judgment in the county court to all forms of action, including fixed date actions, subject to a list of exceptions, exception B being possession of land. So the bottom line is you could never get summary judgment for land in the county court at any point up to the date the civil procedure rules came in. So this can have no assistance to my learned friend in construing the County Courts Act of 1984. The second question was, my Lord, I think Lord Justice Lewison asked what the Common Law Procedure Act said, and I have managed to find what it said, section 212.
I just want to understand this point.
Sorry, the point I was just making.
Yeah, yes, because are you saying that you're saying that referring to the summary judgment rules doesn't help, but you are saying because it now looks as though you're both relying upon what was happening in practice as what might inform the drafter. So from it is right from your perspective, saying, well, if the drafter had thought about what was happening, the drafter would know that you couldn't get summary judgment for land. They were all fixed date actions, but a fixed date action would include, as it were, a non-contested hearing. Is that right? Would a fixed date action include what we now refer to as the undefended possession list?
Yes. There were two ways of commencing process in the county court. One was what was called a default action, and the other way was a fixed date action. And the difference was a fixed date action had a date fixed on the face of the summons, as it was, which was the return day.
Yes.
Possession of land was a fixed date action. You couldn't get summary judgment for any form of fixed date action at the date that Section 138 came into force. So my short point is a negative one. My learned friend can get nothing out of the county court rules to help him with his construction argument on 138, because he made a point that the Section 138, the drafter, hadn't taken into account summary judgment, and he hadn't taken into account that there's an extension of it in the rules of the Supreme Court, Order 14, Rule 10. The short answer to that is you could never get summary judgment in the county court. All you got with possession of land was either what you might call the short undefended procedure on the return day, or you got the full-blown trial. Both of those are effectively a trial on evidence. And as my Lord Justice Lewison observed, in the old days they were heard in open court with serried ranks of counsel waiting to come on, trooping witnesses through the witness box. They were little mini trials.
And it would follow from the point you've just made that whatever Order 14 said about relief against forfeiture after summary judgment couldn't apply to the county court because there was no summary judgment for possession of land, in which case I think we don't need to know what the Common Law Procedure Act said.
Exactly, my lord. And then three, I think, very short
Well,
points.
I think I was making I understand your negative one. I thought you might be making a positive point as well, which is that since this was intended to be 138, was intended to be a comprehensive statutory code for giving relief to tenants in cases of non-payment of rent, the drafter would have known that you could get judgment at the county court on a summary procedure, or no, not summary judgment in that sense, on a summary, which is the undefended possession list.
Yes, I mean,
That's the positive side.
that is the positive side. I thought that was a point which was I'd effectively made already, and Spurgeon's Homes and Gentles is an example of where that happened. And dead against my learned friend, I would submit.
Thank you. Right, what else?
Very, very short points. Section 138(9) capital A was simply an additional right for the additional assistance of tenants. It wasn't really filling a gap in the procedure which runs through 138(3) and 4 and 7. My learned friend queried whether the decision in Croydon Unique turned on the irregularity stroke nullity point or not. The short answer I would submit is it has two ratios. They're both part of the ratio of the case, if that is important. You won't want me to respond to the jury point, but can I say one line, please, Lord? Trespass on your time. My learned friend keeps ignoring the fact in 2014 my client paid £67,507 to extend the lease. That's in May 2014, just under 2 years before the forfeiture, because she's abandoned this flat. I mean, it's a very bad point. And the final. Yes, and finally, Lord, my learned friend's reference to section 139, I'd submit that is a completely different part of the procedural code. There wasn't a peaceable re-entry, it doesn't apply, it's irrelevant. Otherwise, I submit for the reasons which I gave in my skeleton argument, this order is a nullity. If it's not a nullity, it's certainly completely irregular, right to set aside ex debito, and that is the disposal.
Thank you very, very much. We will resume at 2 o'clock. Will you please discuss how you're going to deal with the rest of the case so as to finish it by 4:15?
Got rice?